Well, I want to, before we get back to the legal questions, I want to start with a little factual one. You began by talking about deceit. Is what you said after that apply in the case of an inadvertent mistake contradicted by other documents in the record?
We would say yes. For example, the president's removal order says either this is deceit or at least it's gross negligence. And now, obviously, they've released a letter of counsel, not from Cook herself, 2 days before the close of briefing here, where they contended that it was an inadvertent notation. But of course, it's the sort of inadvertent notation that people could be indicted for, or at least the federal regulators are forcing you to buy back your loans. It's a very significant representation that to the lender, this is going to be my principal residence, because obviously you get a better interest rate if that is in fact your principal residence. So it suffices from our perspective, and therefore there's really no material facts in dispute that the president determined that this is at least gross negligence. Even if it was inadvertent or mistake, it's quite a big mistake, so to speak, in a key financial representation made in the context of interest rates.
Well, I mean, I suppose we can debate that, how significant it is in a stack of papers you have to fill out when you're buying real estate. But I gather under your position it doesn't make a difference, right? In other words, the determination of cause is unreviewable, right? So it doesn't make a difference whether this was an inadvertent mistake or whether it was a devious way to get a better interest rate. Doesn't matter for you, right?
Let me put it this way. We would contend there's judicial review kind of at the outer perimeters of cause, whether something goes to conduct, fitness, ability, or competence at all. But once you're within that, and we clearly are here, then there would be deference to the president. We derive that from at least 3 sources. First of all, the statutory language, cause without further qualification, is itself, in its plain language, a broad, conferral of authority on the president himself. Secondly, we think that places that within the line of cases going from Martin against Mott through Dalton against Specter and beyond, Payne and so forth, where the president has broad discretion, and the court has consistently held in those cases where the president's granted this broad discretion, then that's not judicially reviewable. And there's statements to that effect, obviously, in Marbury itself, that they disregard pages 165 and 166 of Marbury. But even if the court doesn't accept that, there's a further layer here, which is that they've conceded this is an ultra vires challenge, and this court held last term that the standard of review in an ultra vires challenge is very, very high for them and very deferential to the president itself. It kind of dovetails with our Dalton and Martin argument as well. In an ultra vires challenge, the burden would be on them to show that what the president did is entirely in excess of his delegated powers and contrary to a specific prohibition in the statute. So there's kind of 3 ways to get to the same conclusion there, which is that once the president's made a determination, it clearly does relate to conduct, fitness, ability, or competence for that office, then at that point there's no work for the reviewing court to do. The traditional discretion to the president's determination would kick in.